Very much. The next speaker for this session is Mr. Shawan Jabarin, General Director of Al-Haq, a Palestinian human rights organization. Mr. Jabarin was the first Palestinian to be recognized by Amnesty International as a prisoner of conscience. He remained active on human rights issues, calling for prisoners' rights in terms of the Fourth Geneva Convention and for international human rights standards to be respected. He's a veteran activist for a just peace and in the struggle for human rights and an end to occupation in accordance with international law. Sir, you have the floor.
Thank you, Madam Chairman, and thank you all for your appearance today and participation, and thanks for the committee for organizing this important session. Before I start my presentation, I would like to go through to download like a short video, show you, it's called the Virtual Field Visit, show you Area E1, eastern side of Jerusalem. And maybe it will be good. I think it's for 4 minutes. Please.
On the 29th of November
2012, the United Nations voted to upgrade the status of Palestine to non-member observer state.
The vote was seen as a significant diplomatic blow to Israel, who had vociferously objected to it. A few days later, Israel announced the construction of an additional 3,000 units for settlers in the West Bank. Crucially, this declaration to expand the settler enterprise included a statement that Israel would proceed with construction in an area known as E1. E1, short for East 1, refers to a 12 square kilometre plot of land in the West Bank, directly east of the Jerusalem municipal boundary. The northern section runs up to the road 437, skirting the local military base and joining with the built-up area of the Ma'al Adamim settlement. The eastern edge lies alongside Road 417, parallel to the Megadim neighbourhood of Ma'al Adamim, which will allow for significant expansion of what is already the third most populous settlement in the occupied Palestinian territory. The E1 area covers 22,000 dunams of confiscated Palestinian lands, belonging to the villages of Abu Dis, Azariya, Isawiya, Anata, Atur, and Azim. The southern boundary of E1 protrudes to the edge of the Palestinian town of Al-Azariya. Along the western edge, the settlement will all but encircle the village of Al-Zayem and join with the existing annexation wall in the northwest, to completely cut off Al-Zayem from the neighbouring Palestinian village of Anata. There are also over 20 Bedouin communities that are at risk of being relocated to make room for settlement expansion. Many Bedouin families have already been forcibly removed from their land in the E1 area. The traditional way of life and the livelihoods of the Bedouin people rely on large open areas to graze livestock. Due to the Israeli construction of settlements and associated infrastructure, such as bypass roads, the area available for grazing continues to shrink significantly. The E1 area forms a vital passage joining the northern and southern sections of the West Bank, as well as Jerusalem. The closure of this corridor effectively cuts the West Bank in two, severing its territorial integrity. Construction in E1 would create a continuous Israeli settler presence from occupied East Jerusalem up to the edge of the Jordan Valley, all of which lies on Palestinian land. The section of the Jordan Valley between Ma'al Adamim and the Dead Sea is also part of Area C. Under the Oslo Accords, this land forms part of Palestine. However, Israel retains temporary full control over security, planning, and construction in Area C. As a result, Israel imposes military checkpoints and prevents Palestinians from accessing their land without permission from Israel, which is very rarely granted. If the plans for construction in E1 continue, Palestine would effectively be divided into 3 cantons of the Upper West Bank, Lower West Bank, and Gaza. When combined with the restrictions imposed by the Annexation Wall and the Oslo Accords, it is clear that there is little prospect for a self-sufficient, economically viable state.
I prepared my presentation. It was a long presentation, and after that, in the first day, I cut it to be short. Today, I changed completely because I don't want to repeat what Mrs. Shante said and what the others said. I don't want to make you frustrated or disappointing, from my presentation. But I would like to highlight a few main legal things. One is to go back to the root of the problem. You saw here, that the people they forced they transferred them forcibly, directly or indirectly. That's not the case. They were in Negev desert, and they were forced outside of their land in 49 and 50 and 51 after the Israel established. It means that their land is in Negev desert. And now they are refugees here also. And they are pushing them out of the lands in different places. I think we have to see the big picture also, the root of the problem. And this committee, I think, it's also mentioned, and part of its mandate, Palestinian people, and here the definition of who is Palestinian. I think this is an issue we have to address when we deal with Palestinians, not just to deal with them in West Bank and Gaza Strip. We have to address the root cause of the problem. Another thing is, I would like to say a few things, not just legal issue. The Palestinian case, I think this is the most reaching case written about from scholars, from UN different resolutions, different reports. If you go to the UN archive, you will see, I think, hundreds of thousands of pages written about Palestine. The question is not about to speak about the situation or to see what's the legal aspects of this situation or this case. The question is the implementation. The question is about the actions. The question is about the third state parties, if they are responsible and if they are, respect their obligation under the international law or not. That's the question. Our case continues for these decades, not because we have a lack of legal analysis or understanding of the case. No, because of the lack of the implementation and the lack of respect of the legal obligation under the international law. Here the case is. And I think we have to address, here the question, why this has happened and what we can do to push forward all of these things. Israel, they are selective in their implementation of the international law. Just 2 days ago, I read a ruling from the High Court, and one of the judges, he said that the Israeli military commander in West Bank, he has the full authority even to demolish houses for security reasons or for military necessity, including also Area A. And he referred to the Hague regulation, That's, here they are very, very selective. The question is, do we want to let them going on in that direction, or do we want to change this situation? If we want to change this situation and to end the suffering of Palestinians, legally speaking, I think the international community, the third state parties, they have a legal obligation to act, not just only not to recognize the illegal actions, and not only not just not to aid. It's also another positive, and I think it's clear also in the advisory opinion of the ICJ in 2004. That's the issue, and that's the case. I know that there is no political will. The problem is not with the people on the ground. The problem is with the states. That's the case. And there is no political will from most of them. Another thing is we have no legal remedy on a domestic level. We have no legal remedy in the Israeli judiciary system. And it's clear. Another thing is what's going on, it's part of a long-term plan. It's systematic. It's widespread. It's continuing. It's part of a policy, an official policy. It's not just an isolated incident here or there. And the settlements, it's not just, an isolated incident. No, it's an official, it's clear, and it affects all aspects of Palestinians' life. And here, when we call, it's not just a war crime. I think it's beyond that. It's also a crime against humanity, and I think we can constitute part of the actions, the policies, violations as persecution. And I think it meets the criteria of persecution according, the criteria of ICC statute. Another thing, it's about a pillage. Pillage also, it's a war crime. And I think taking resources, controlling resources, confiscate and using resources for the benefits of the Jews, this is an issue. The occupying power is not taking care with the interest of the protected persons under the occupation. And this is another thing when it comes to the natural resources. Water is part, land is part, sin is part, everything they are taking, and they are benefiting. And there is a principle in the international public law also. No one has to benefit from a wrongful, act. And this is the Israeli, I think, intervention, the main one before the ICJ in 2004, when they spoke about Palestine has not to be, benefit from a wrong act or something. This is, I think, the principles we have to apply it to the Israeli actions. This is part of the story. I would like to address another thing. And this here, it's my message to the Palestinian leaders. It's about land swap. How we can legitimize the illegitimate. In our point of view, legal point of view, we think that it's illegal completely to speak about land swap because the main purpose behind the land swap is to keep settlements. That's the case. And even the international community, they repeat the same things. And here also it's illegal. I raised this issue before, and I have been raising this, and we will continue to raise it. In our point of view, Palestine under the occupation, it's an occupied territory, under prolonged occupation, and any agreement we have to reach with the occupation, it has not to undermine, any guarantees in for Geneva Convention. Part of that, for instance, which it's illegal according Article 49 to transfer civilians, to occupied territory. I mean here, the settlers to the occupied territory. It's clear, it's a grave breach. And in the same time, the purpose behind the land swap is to keep this enterprise, the colonists here. And the Palestinian Authority, they have no right to do that, according Article 47 of the Geneva Convention and Article 7 of the Geneva Convention. That's the case. And I think now it's a time to leave that and to drop this from the table of negotiation. And here my call also to the committee and to all the states. They have not to recognize that, and they have not to repeat again and again. I know it's happened for political reasons, but for speaking legally, it's not, legal issue. The exchange, or let me say land swap, there is nothing said in international law, it's illegal. But this is between two sovereign states. And each one has its own criteria, for instance, to vote, to participate, to do all of these things. But here we are speaking about a case under the occupation. And because of that, it's illegal. Go and see Article 47 in the Geneva Convention, what it says, and go and see Article 8 and Article 7 of the Geneva Convention. Even the people, the protected persons, they have no right even to say and to go under the guarantees in the Geneva Convention. And this is one of the main, I think, things that we have to think about as Palestinians, as international community, as states, and everything like that. The question here, it's about how we can build, like, let me say, strategy to push forward law. I think now Palestinians, they lost their hope regarding the international law when it comes to international law. They feel that it's selective in implementation, and it doesn't work when it comes to Palestine, not respected. I think this is a danger for a long term. I would like also to emphasize on the other point that I mentioned regarding the land swap. The main countries they pushed for that is France. During, in 46, 47, and 8 at that time in the diplomatic conference about Geneva Conventions. And in their mind, it was their experience that the German, at that time, they tried to push for a fishy government and to have like an agreement with the fishy government as a representative of the French people under the occupation at that time. And the French, they came with that experience and they said, no, we have to protect the rights included in this convention, and we have to take attention about 1, 2, 3, 4. This is from their experience. The Geneva Convention, it's not a Palestinian convention. Could you please just respect? Another thing is the first article of Geneva Convention, respect and ensure respect. This is, I think, brings me here to that there is a legal obligation under Geneva Convention. The other point, it's about business. And here, each state has a full responsibility for their citizens, for their legal titles, companies, things like that, not to acting in violation of international law and the principles. And here they have not to benefit from the illegal actions. And I think here it brings me to the companies that they are benefiting now from the continuing of the occupation. They are benefiting now from the settlements. And this brings me also to another point, because I'm here now in Belgium. This is the place where the EU institutions, I know it's a good step that they are now speaking, and I hear that in a few days that maybe they will move forward regarding labeling. Labeling is not enough. Is not enough completely. What we are asking for is banning, and there is a legal basis for banning. Labeling is exactly like one who said that this is a stolen material, but you can't buy it. Exactly like that. If they stuck in that, this is the case. But if it's part of a plan to ban, identify, or distinguish to ban, Yeah, that's the case. That's what we are asking for. It took them 50 years now to label, and how much it will take them to ban. That's, I think, the issue. I don't want to go through all of these details. I will leave that for the discussion because I promised the Mr. Chairman that the time my colleague he took, that I will pay the price of the time. He's a Palestinian, I'm a Palestinian too, and we will pay the price. Thank you very much.